Hi, everyone. Welcome to our panel on global developments. Let's just make sure that all of our speakers are here. I see Yuval and Or, but I don't see Moshe yet. Oh, okay. So here, Moshe joined us. We have really great speakers. Each speaker will have 12 minutes to present, and then we'll open it up for the Q&A. Our first speaker today is Professor Yuval Shany. Yuval Shany is the Hersh Lauterbach Chair in International Law and former Dean of the Law Faculty of the Hebrew University of Jerusalem. Among the many things that he's done, he just finishes an 8-year membership in the UN Human Rights Committee. He's the Vice President for Research at the Israeli Democracy Institute and co-director of the International Law Forum at the Hebrew University Law Faculty. And he also leads the Cyber Law Program of the Federman Cybersecurity Center. And now, when he's no longer my PhD supervisor, I can tell you that he's also a great person and a great mentor. And Yuval will talk today about normative and institutional gaps in the context of cyber attacks. Yuval, you have the floor.
Thank you, Yali. I'll share a presentation, just a second. So thank you, Yali, and thank you all for staying on. This is a presentation that I'm giving in my capacity as director of the law branch of the Federman Cybersecurity Research Center. And the topic that I really want to talk about, the gaps, institutional and normative gaps, and to raise the question whether we are on the verge of a new legal paradigm in this field of cybersecurity. So for those who have not been following closely this fast-moving field, this is an area of interaction between states, so to put it. We have seen cyber attacks which have been launched in an interstate context as of the middle of the previous decade. From 2007 onwards, we have started seeing major attacks which went beyond just criminality. And as we will see, the number, the frequency, the scope of these attacks is constantly on the rise. But so far, I think it is fair to say that international law, and more precisely states, engaged in this field, either on the receiving end or on the other side, on the side, the more aggressive end of this, have opted for what could be called as a thin regulatory paradigm. Namely, we do not have a major treaty, a major instrument that establishes the rules of the game, so to speak, in cyberspace. States have been for many years silent and ambiguous about how they understand their rights and obligations in cyberspace, both vis-a-vis one another and also vis-a-vis private actors that operate at some level under their jurisdiction. We have seen attempts by experts. Yali has written a little bit on this as well, these are experts which are independent experts, albeit with some governmental affiliation, to develop codes of conduct that are generally based on kinetic, so to speak, international law. And the most famous of these efforts is Tallinn I and Tallinn II, which was complied earlier this decade. We have seen at the UN some movement to reach some understandings about the rules of the game at the international, interstate level. But these efforts, I mean, the most spectacular recent effort in 2017, the GGE, the group of governmental experts, has collapsed in that states didn't really agree on anything. the major states on what are really how international law applies. And the stakes are high because these are not, in terms of the legal issues, there are very serious legal issues that have not been really, that are really contested in the field. So whether sovereignty is a rule or a principle, this is one organizing question, which really affects the question as to whether there is a specific limit on the ability of states to exercise some form of governmental authority directly or indirectly in the, so to speak, cyber territory of other states, or whether there is some exception, for instance, for espionage that we have here on the screen. Well, how do we understand data? Is it an object in IHL? Can an attack against non-tangible assets, could it be considered an armed attack? Does the non-intervention principle limit, for instance, influence campaigns? So these are not first hypothetical questions, because these cyber operations do take place on a, as I said, on an almost regular basis. But also they are not theoretical questions, in the sense that they really are like the basic building blocks of any international law regime that can apply in cyberspace. So we do not have agreements, and we disagree on the basic elements of international law that could have substituted these agreements. And then the same goes for what you could see, the institutional or the more enforcement part of the picture. There has been no, although there has been some writing on this, and there have been some initiatives by private groups. I mean, Microsoft has come up with an initiative, the RAND Corporation has come up with an initiative. I wrote an article with Mike Schmidt on this. Dan Efroni and I have written on this, but there has been so far very limited interest in the idea of developing somewhat of an attribution mechanism, an international mechanism that would be able to identify, in the event of a cyber attack, who was behind the attack. We have actually seen, and Dan Efroni and myself have written on this, very limited even use of countermeasures in the explicit sense of the word. So states did engage in somewhat below the radar screen. So mysteriously, we have seen some attacks occurring, some misfortunes occurring in certain states after these states have been reportedly involved in certain attacks. But everything that has been happening was happening either below the radar screen or through retortions, which are sanctions that do not involve an infringement of legal obligations. So deporting diplomats or taking some trade measures. I mean, these are the type of reactions that we have seen. And there has been also a lot of talk, a lot of controversial talk of using private hackbacks, namely allowing companies to defend themselves by actually targeting those computer points of origin from which attacks against them have been launched. So it's really like a Wild West in terms of how the enforcement apparatus has come into play. Now, the big question is really whether this is sustainable and whether states continue to believe that this is sustainable. And here, I think what we are seeing in 2020 has been perhaps one more year in this process, which I think suggests that the answer is probably not, that this is not sustainable, and that states are increasingly accepting that this is not sustainable. So what we have seen in the last 3 years is first this development of the global attacks. I mean, we have seen a movement on the attacking side, from just attacking this or that company, stealing information, stealing data, destroying this or that piece of infrastructure, to what are almost global attacks. And WannaCry and NotPetya are major candidates for this, but also SolarWinds that we are seeing now in the United States, which is affecting many countries, including allegedly Israel. This is really, these are really operations that have very dramatic ripple effects, which probably are not even fully understood by those who are engaging in these attacks, and they do create significant havoc. And I will also note that in the aftermath of COVID, we have seen some very nasty ransom attacks in hospitals and medical facilities, including the stealing of the Pfizer patent application from the European Medical Agency. So this is really, these are really developments that are becoming more serious in their scope, more serious in their implications, and more lethal. And also in Israel, I mean, 2020 has been a bad year in terms of cyber attacks. We have seen in April, there have been reports that there have been attacks on water installations, allegedly designed to change the level of chlorine that is actually introduced into Israeli water supplies. This is, of course, very serious. If this is true, this could have been a very serious development. In response, there have been, again, reports, all of this is happening under the radar screen, that Israel has attacked computerized facilities in Iranian ports. And now we are in the midst of another major data theft operation, which has affected some Israeli companies, including, I will single out Amital, which is a company, a not very well-known company, but it is a company that provides information on transport, import. Well, the joke was Rappaport, but it does provide facilities for which are related to trade and to transport, and basically stealing their clients could affect the supply chains for critical infrastructures in Israel. So these are really serious developments. So on the one hand, we are seeing deterioration in the state of cybersecurity, which is really a universal problem. And at the other end, we are seeing movement by states. And I would say that that movement is happening at two levels. One is the move to multilateralism, and this is something that we have seen in the aftermath of the NotPetya and the WannaCry attacks in 2017, an increased interest on the part of states to basically point the finger at states who have been allegedly behind cyber attacks, but not to do this on an individual basis, but rather at a collective basis. So we are seeing groups of states, sometimes these are a few dozen states, sometimes it's a handful of states that are issuing legal statements that are accusing Russia or China or Iran or North Korea of being behind an attack. And we have seen this increase from 2018 onwards. This year we have seen such a finger pointing with respect to an attack that happened in 2019 vis-a-vis Georgia. We have seen also the EU sanction regime come into play, which is a blacklisting system. It was launched last year. It started being applied this year. Again, mainly vis-a-vis Russians who were involved allegedly in the OPCW hack, which is an attack against the computer facilities of the Organization for the Prevention of Chemical Weapons, which was investigating a Russian use of chemical weapons allegedly in Salisbury. So everything is really coming together. We've also seen a resumption of the GGE and the open-ended working group process at the UN. So there is more, another attempt to go multilaterally. And another interesting development, so over and beyond multilateralism, is what I refer to as increased transparency, and that is an increased propensity by states to come out openly and declare what are their main doctrinal positions on the big issues that I've defined before. Yali, how much time do I have?
10 seconds.
10 seconds. So I would need maybe 2 minutes to wrap up. So we have seen countries like the UK in 2018, and this year New Zealand and Finland come out with doctrine. There have been other countries as well. I would also note that Roy Scheindorf, the Deputy Attorney General, has also come out, I think along the same lines a few weeks ago, with a speech at a major international conference on cybersecurity, where he laid out the main elements of Israel's position on some, not all of these issues. And I think that we are going to see from 2020 onwards, an increased attempts by states, or an increased attempt by states to diversify their toolbox and to move away from just operating outside the law, below the radar, bringing on the law in a more aggressive way, which would mean that they would have to be more precise about their legal theories. And indeed, we were just notified a few weeks ago that Tallinn 3 has been launched, so there will be another push to further clarify the rules of the game. We have seen the statement by the incoming President Biden that he is taking very seriously the SolarWinds attack, and that he is determined to basically, together with US allies, to exact the costs from those behind these attacks, which means that this would be a change from the traditional position of the US, which saw these attacks that are infiltrating into computers to obtain data as legitimate espionage. So the espionage exception is also would probably be under consideration. I saw before Asaf Lubin on this call, and he has already written a very interesting blog on this. And then comes the question of whether these elements, the increased multilateralism, the increased reliance on rules, and the increased move towards sanctions, especially at the EU level, is it going to generate more interest in creating mechanisms such as international attribution mechanisms that could provide the missing institutional component for this move towards greater reliance on international law, at least as an optional avenue in those cases where just relying on one's own deterrence capacities do not cut muster. I'll stop here, Gali. Thank you.
Great, thanks, Yuval. And our second speaker is Professor Moshe Hirsch. Moshe is a professor of law and international relations at the Hebrew University of Jerusalem. He's the co-director of the International Law Forum here. And he published extensively, and his scholarship often involves interdisciplinary research that employs inter alia sociological theories, game theory, political economy, and international relations theory. And Moshe will talk about the ILC work on immunity of state officials from foreign criminal jurisdiction. Moshe, you have 12 minutes.
Just a second, please. Okay. So I will briefly talk with you about the recent draft articles of the International Law Commission with regard to immunity of state officials from criminal jurisdiction. Actually, the ILC has provisionally adopted 7 articles, and there are additional 11 articles on the way, and I will only talk about with you also only about very few articles. I believe that they are the more important provisions. So let's start with the first provision, that actually it constitutes a codification of well-established practice. We are talking about the Troika, I mean foreign ministers, prime ministers, and heads of state. And Article 3, you can see, grants these 3 very important persons quite a broad immunity. Just to make it clear, here Article 3, it relies on the ICJ judgment with regard to the arrest warrant, and also it relies on many decisions of domestic courts. Now, the first question here, whether additional ministers, like the Minister of Defense or Ministers of Commerce, whether they are also included in this very privileged group. If you read the decision of the ICJ with regard to the arrest warrant, there is a clear sense that this list, it is an open list. Yeah, actually the ICJ is talking about high-ranking officials. And similarly, if we read the decisions of some lower courts in the United Kingdom, the Mofaz case and Boshilai case, but the ILC decided here to adopt a narrow interpretation of existing practice. The draft Article 3 does not refer to any additional minister or high-ranking official. So the list seems to be closed. But perhaps the reason for this narrow approach, because of the second category of immunities, the substantive immunity, and I will talk about that soon. Let's continue with the Troika, these three very important persons. So they enjoy personal immunity while they are in office. While they are in office, they enjoy very broad immunity. I can say absolute immunity. Article 4 clarifies that this immunity applies to all acts that were performed while they are in office or before they are in office. We are talking on both private and official acts, and they include, I mean, this immunity applies also to crimes, international crimes, or violations of jus cogens. But what happens when they are out of office? Then these very important persons, their immunity will turn into substantive immunity. Yeah. Now, talking about the substantive immunity, here we can see a significant, I would say, innovation or change. The number of people that they enjoy substantive immunity, it is greatly expanded. Article 5 is talking about state officials, that they enjoy substantive immunity, and the definition in Article 2 is clearly talking about any individual who represents the state who exercises state functions. I mean, we are talking here about many soldiers, policemen, yeah, not only very important persons. But the immunity here, it is much more restricted if we compare it to the personal immunity of the three important persons. Here we are talking about only acts that are performed in an official capacity. And actually, at least one tribunal, the PCIJ tribunal, in a very recent and very interesting case, I'm talking about the Enrica Lexi Award, it's about the law of the sea, yeah, this tribunal has already applied this provision of the ILC, and actually this tribunal has extensively cited these rules of the ILC and the commentary. Again, we are talking here about soldiers. I mean, the tribunal applies this substantive immunity to 2 Marine soldiers of Italy. Now, after they complete their term in office, regular state officials, they enjoy only substantive immunity with regard to acts performed in an official capacity, and almost the same, or the same is true with regard to the Troika once they finish their office. I mean, after they finish their office, actually, all officials, both these 3 very important persons and regular state officials, they enjoy the same kind of immunity. What about international crimes? The most contested, the most controversial question in the ILC work in this field was about the question whether international crimes committed by both categories of persons, whether they can enjoy immunity if they commit international crimes. Article 7 of the ILC draft articles clearly says that if we are talking about these 6 international crimes, there is no immunity. Yeah, there is no immunity, and I must say we are talking only about substantive immunity. I mean, if we are talking about these three very important persons, we are talking about the period after they finished their term in office. So if they committed one of these 6 crimes, and these are I mean, here we have the 4 classical crimes, and we have the crime of apartheid for African countries and forced disappearance for Latin American countries. And if we have one of these crimes, there is no immunity. It was a very controversial issue in the Commission, and Article 7 was adopted by recorded vote, which is quite rare in the ILC work. 21 members were in favor, 8 voted against it, and 1 abstained. It is quite significant to say that the members from United States, Russia, China, Germany, UK, India, and Slovenia, they voted against it. If we are familiar with, let's say, textbooks or many articles written about this issue, let's say 5, 7, 10 years ago, we can see that Article 7, it doesn't constitute a surprise. I mean, actually, it is a widespread interpretation of the Pinochet case or Article 13 of the resolution of the Institut des Droits Internationaux. Yeah, but still it was a very controversial issue in the International Law Commission. So the last question is, does Article 7, does it constitute customary international law? Well, I think until the ILC started to work on this issue, for most of us, or in most books, it was seemed that no. I mean, the Pinochet case clearly showed that that the answer is yes, that Article 7, by and large, it reflects existing customary law. But after the controversy in the ILC, among the members of the ILC, we can see that there is a significant resistance to the rule which is embodied in Article 7, and we can see that the international law community is divided about that. Yeah, and we have significant actors like the US, China, Russia, and other major powers, they do resist this rule. So I think that for the future, it depends whether this question would arise before the International Court of Justice. Based on previous decisions of the ICJ, I think that the ICJ is not likely to say that Article 7 reflects international customary law because of the significant opposition, yeah, to this rule. But if the very same question, and I think it is more likely to arise before domestic courts of Western countries, Britain, the Netherlands, Switzerland, and so on, these domestic courts are much more likely to follow the Pinochet case and to say that actually Article 7, it constitutes international customary law. And then perhaps, if we see an accumulation of such decisions of domestic courts, then we will have new customary rule of international law. Thank you very much. I'll stop.
Thanks very much, Moshe. And our last speaker is Dr. Or Rabinovich. Or is a lecturer at the International Relations Department of the Hebrew University of Jerusalem. Her research interests include nuclear proliferation, nuclear history, and Israel-American relations. She published in leading IR journals, and her book, Bargaining on Nuclear Tests, was published in 2014 by Oxford University Press. Or holds a PhD from the War Studies Department of King's College in London, and she will talk about Iran, the Biden administration, and the nuclear deal different possible scenarios. Or you have 12 minutes.
Thank you very much, Shali, and thank you everyone for having me. I've shared a PowerPoint presentation, so if you can just indicate whether you can actually see the presentation. Thank you. So I'm very happy to be here today because my undergraduate degree is actually in law, and my academic path has since digressed. So it's very appealing to me to somehow touch base with my previous course, let's say, or previous career path, the road not taken. But today, alas, we're going to talk about some other things rather than my forgone legal career, and we're going to discuss the different scenarios that the Biden administration, the incoming administration, will consider in the Iranian context. And before we even begin, I want to frame our discussion. I don't think we're likely to witness a similar level of cooperation compared to the cooperation we've seen recently between Prime Minister Netanyahu and President Trump. It's hard to imagine. It's not impossible, and we may be surprised, and the two leaderships and administrations may get on swimmingly. But I think that realistically speaking, it will be harder to achieve. Especially, I think this conclusion strengthens if you consider media reports and different reports about how the current democratic leadership and people that are likely to take office and to be influential in the Biden administration have rather negative views of Netanyahu and his Iran policy and his attempt to block the JCPOA, the JCPOA, or the agreement we call the Iran nuclear deal. And it seems that there are lingering negative sentiments towards the Israeli policy in this respect during the Obama administration. And it remains to be seen how these lingering negative sentiments will impact the future relationship between the administrations. And of course, since we are ourselves going into our fourth elections, there's no telling who will sit on in the Israeli Prime Minister's office in March or whatever, or maybe we'll have a fifth election, so time will tell, but there are a lot of unseen's obviously in this equation. So the biggest question is, are we likely to see a straight path return to the JCPOA? So in January, the Biden administration and the officials will gradually take office, they'll be confirmed, and then they'll just make what we call a beeline and just return to the JCPOA immediately and swiftly. I don't think it's likely, and I'll explain why. But first of all, let's try to assess the likelihood of such a policy. So we've seen different statements from the people who are tapped to take high-ranking positions in the administration, indicating a motivation and an interest in returning to the JCPOA. And you see here on the screen Antony Blinken, who's the Secretary of State designate, and we've also heard from Jake Sullivan, who was Biden's pick for National Security Advisor, and we've seen Biden himself refer to the issue, and all of these statements basically indicate the same, and they indicate Biden administration motivation to return to the JCPOA. And it's a move that Netanyahu, as other Israeli officials who may be out of office in the coming months, with no way of telling what will happen as of late December 2020, they've already signaled a strong opposition to this move. And it seems that if these two, let's say, policies will remain in place in the coming months, it's very likely that we'll see a clash of positions. But I think the situation is actually more nuanced, and I'll explain. First of all, there are a few hurdles in the path towards a return to a JCPOA. You can never return to the same river twice, as we all know. And Iran today is not in the same place, and it does not occupy the same place that it has occupied in 2018 in May, when the Trump administration withdrew from the JCPOA. In the first year, it still remained in that same place, but in the year following Trump's withdrawal from the JCPOA, Iran is taking several steps which basically has promoted its nuclear program. It resumed R&D operations on more advanced centrifuges. It has stockpiled low enriched uranium or uranium that has been enriched to a level of 4.5. I won't go into the technicalities, but it's more than it's supposed to have. And they may opt to develop and achieve other technical abilities, which they would now have, but previously they did not possess. So coming into the new debates, Iran will be in a completely different stage of its technical program, and it won't be as easy to roll back these developments, or at some point it may actually be impossible, because once Iran achieves a certain technical knowledge of how to do certain technical things, it's impossible to roll that knowledge back. There are also other elements we need to consider. And another interesting point of view, which I found, or let's say, which I think is worth contemplating, is the fact that there's actually also a competing camp within what we foresee will be the Biden administration. I can't pinpoint the exact voices, so I'm mostly referring to some leaks, anonymous leaks in media, in interviews in the media and such, but it seems that some officials think that it actually may be a good idea to take advantage of the leverage created by Trump's maximum pressure policy. So Trump's policy up until now, has been to pressure Iran, or to apply what we call maximum pressure on Iran. And the Democrats, by and large, have criticized this move. But the move, despite them criticizing it, has actually created a lot of leverage, because the Iranian economy is suffering. And you can only imagine that it's suffering doubly, because it's being hit by the COVID-19 crisis, as well as these crippling sanctions. So there is a window of opportunity to use the leverage created to maybe push Iran to accept some extended conditions on the existing deal. So it's not quite clear which of these two camps that I've just described will win the jostle at the end of the day. It remains to be seen. After all, these officials have not been confirmed yet. Biden has not been sworn in. Unfortunately, we still have 3 weeks of the Trump administration to handle, so things are very much up in the air. Interestingly, there are other voices, not from Israel, but from other allies, who also indicate some international interest in adding or extending the existing deal. And I'm going to give you some quotes, and you can see the link below. It's from Deutsche Welle. So first of all, we can examine this interesting quote by Heiko Maas, the German foreign minister, and he says, "A return to the previous agreement will not suffice anyway. There will have to be a kind of a nuclear agreement plus." So we see an indication that the Europeans themselves would like to see the existing agreement extended. And again, France and the UK have joined Germany here, and I'm quoting here again from the same news article. In a statement released earlier in December, the EU3, and I'm quoting, welcomed a diplomatic path to address wider concerns with Iran. So clearly the E3, as is Israel, as are other actors, the Gulf states, Saudi Arabia, they're all interested in seeing a path to somehow deal with the Iranian nuclear program in a wider lens compared to the existing lens. And finally, there's a very interesting quote by Rafael Grossi, the Argentinian head of the IAEA, the new head. And a few days ago, he said, "I cannot imagine that they're going to simply say we are back to square one, because square one is no longer there." And when we refer here to square one, we refer to Iran's ability to go back to where it was, let's say, technically speaking, in May 2018. So you see a whole range of actors in the international community really indicating or signaling to the Biden administration that there is strong interest in somehow amending or extending or working, or not just accepting a return, and a regular immediate return to the JCPOA. Yali, can you indicate how many minutes I have? Okay, so I've been quite fast. Okay, so my apologies. Another question we have to consider when we take into consideration the paths ahead of Biden is the question of sequencing and timing. So first of all, despite the fact that both Tehran and Washington have indicated officially that they would ideally like to return to the JCPOA, it's not at all clear who will make the first move, how the sequencing will work. The US ostensibly wants Iran to roll back the added advantages it has gained since May 2018 and return to the JPOA. And ostensibly, once it does so, the US will remove the added sanctions, but Iran wants the reverse to take place. Iran wants the US to roll back all its sanctions, and only then, according to existing statements, will it consider joining the JPOA. So we have an issue of sequencing, who will bow down first. Second of all, we have an issue of the Iranian timeline. Iran is going to choose a new president this coming June. And according to existing indications, the new president is likely to be, let's say, less pragmatic and more of a hardline president. And the question is, can the US or can the Biden administration manage to achieve anything with the current president, President Hassan Rouhani, and you see this photo here in the PowerPoint presentation, in the very short time span between January, when Biden is sworn in, and June, the Iranian elections. And it's not at all clear that it would be possible because, and again, I don't have to explain it to this esteemed forum, when we talk about legal agreements that usually take months and years to negotiate, it's not at all clear that any possible way forward will reveal itself between January and June. It seems like a very slim, very slender window of opportunity to negotiate any possible way forward. Another point I'd like to make is the point regarding how Israel and its role and its relationship with the US is framed. And I think the discussion and the reports around Fakhrizadeh's assassination here are relevant. And we've seen two competing explanations, two different frameworks when Israel's role here, or Israel's signal to the US was weighed by the media and by different analysts. So one group, or the first camp, basically accused Israel of trying to tie Biden's hands by taking out Fakhrizadeh, and Israel has been very silent in basically shying away from taking responsibility for Fakhrizadeh's assassination, we have to say. And I'd just like to remind everyone that when Trump wanted to refer to this episode, he was basically tweeting Yossi Melman's tweet in Haaretz. So it was really telling us what he thought about who was responsible here. But the opposing way, or let's say the competing framework here, and this is what I think Israel should do. I think Israel should push back against this kind of framing when it approaches the Biden administration, basically point out that this was in the past. Let's say this was during the Trump administration, and that in essence, Israel was essentially buying time and rolling back some of Iran's capabilities in a way which would basically buy more time for Biden to deal with the program. And I think in the bottom line that the Israeli leadership, whether it's Netanyahu or a new prime minister that will be sworn in, I think the leadership needs to maintain open lines of communication with the Biden administration and to make sure that any traces of hostility are basically dealt with. I think they would be detrimental to Israel's ability to deal with the Iranian crisis, to deal with the Biden administration. And last but not least, I'd like to conclude with, let's say, the question of whether we are indeed facing a new Middle East or not. And personally, I was very happy to hear about the Abraham Accords and Israel's new friends in the Gulf and the thawing relationship with Saudi Arabia. But I think it's very important to remember that when push comes to shove, these new friends will not assist Israel, will not provide military assistance, will not provide any kind of, let's say, comfort, so to speak, if a conflict erupts. And it's very important to remember the context of these relationships and the role they play. And I think it would be very important for Israel to remember that its one true ally is the US, and that this relationship should be maintained, and Israel should work with the US in this context. That's enough for me. Thank you, Yali.
Great. Thanks everyone for really interesting presentations. We now open it up for about 15 minutes of Q&A. And our first question is from Shani Friedman. Please, Shani. And or can you maybe stop the share?
Thank you, Yali. My question is for Moshe, and I was just wondering whether the ILC addressed the issue of detention and transfer of states officials to international tribunals, especially after the case of the ICC versus Jordan, which kind of ignored the issue. So, thank you.
Should I answer or?
Yeah, sure.
Yes, actually, the ILC addressed this issue, but in a negative manner. I mean, they have had enough controversy about Article 7, so they explicitly wrote that the rule cover only immunity from criminal jurisdiction of national courts, and it is without a prejudice to the immunity before international courts. So they really avoided this this bomb, indeed.
Yeah. Our second question is from Maria Varaki, and please, if you have questions, just indicate that you want to ask in the chat.
Okay, thank you very much, Yali. Can you hear me?
Yeah.
Yeah, so my question is for Yuval. Yuval, I was wondering, how do you read, assess this increased multilateralism within the cyberspace compared to what we have this predominant discourse and argument about the backlash against multilateralism? Does that mean, you know, that this phenomenon that you described in the particular area, does it reiterate, you know, counter arguments that I mean, international scholarship exaggerates when it talks about a generic backlash. It is more like a cherry picking, that we have to be in a more nuanced position about multilateralism. Thank you.
Yes, exactly. I don't think there is a general change in philosophy about multilateralism, but it is interesting that it is the United States that actually came out with, in 2018 under Trump, with an international cyber deterrence initiative that really made multilateralism as a central point in this. And I think it's really about the idea of. So I think there is a sense of, you know, some things states can do it alone, and some things cannot be done alone. It's really a question of what is the default, okay? So I think that for the Trump administration, the default has been to do it alone. Unilateralism, and they resorted to multilateralism, you know, on a case-by-case basis. And I think in this field of cybersecurity, they reached the conclusion that, I mean, they're outgunned, they're outnumbered by all these groups of hackers that, you know, operate below the radar and inflict significant economic harm on them. So there, I think they have reached the point that maybe it's better to go multilaterally. But I wouldn't say that this would translate itself into other areas. Now, it's interesting now with the upcoming Biden administration, this maybe would comment on this. This may be a different philosophy, because for Biden, multilateral, and he said that repeatedly, that for him, multilateralism is actually important, and that he sees the United States role in the world as being a leader, and they will join the Paris Accords on day one, et cetera, et cetera. And also in cybersecurity, in his short statement, he did emphasize that he is planning to engage in these challenges multilaterally. So I wouldn't, you know, read too much into it about a general philosophy about the world. There is, of course, within the US, there is a certain fluctuation. The European context is different, because Europe, I mean, has always believed in multilateralism. I mean, this was you know, they are the last bastion of multilateralism. So they are the constant here. I think the Chinese and Russians are, I mean, they have their own, you know, views on multilateralism, which is, I think, pretty much in line with the Trump administration approach, that multilateralism is not the default. So really the changing factor here is the US. And I think for the US, we are seeing in this field a move, but it may have implications for the US in other areas of the law.
Okay, so I have questions to all three speakers, and maybe I'll do it in a reverse order. So, or I wonder whether these wider concerns include also issues that are not related to nuclear weapons, maybe the engagement, other military engagement of Iran and so on that were also discussed in relation to the agreement. To Moshe, your presentation, you addressed customary international law, and it reminded me that recently the ILC also published its very controversial approach towards customary international law. And it seems to me that, right, you did not rely at all on the ILC study when you discussed customary international law, and I wonder about what's your position regarding the role of the ILC in international lawmaking, because here you looked at the role of the ILC as a lawmaker, but, right, ignored its role when it comes to customary international law. And to Yuval, in the first part of your presentation, you've mentioned the paper that you wrote with Danny, and there you emphasize the reluctance of states to engage in discussion on the legal regulation of cyber. But here at the end, you've mentioned this trend towards transparency, and I wonder what triggered it. It wasn't entirely clear to me.
Okay, so I will kick it off. Of course, Yali, you made very important points. I kind of skimmed on it, but the other side of the coin for Trump's maximalist approach, or the maximum pressure policy, was to push Iran to accept a new and improved deal, which would also, in addition to dealing with its nuclear program, would constrain its missile program, as well as what we call Iran's regional involvement. So its support for proxies like Hezbollah and its involvement in Yemen and in Iraq, etc. So the maximalist approach would basically advocate a new agreement which deals with these three issues as one unified Iranian portfolio, where let's say the existing approach is the more minimalist approach, which is the approach that existing JCPOA takes, and that agreement only deals with the Iranian nuclear file. But if you remember the quote by Heiko Maas and others, they're actually not calling to relinquish or to completely abandon the existing nuclear accord, and they're not calling to adopt a maximalist approach. They would like to see the existing nuclear file extended. And how do we translate this? We believe that what they're basically trying to do is to take the sunset clauses, or the clauses within the agreement which basically have a sell-by date and are about to expire in a set amount of time, roughly 5 years from now, and extend them, or maybe remove the sun from setting on them and extend them indefinitely, but staying within that confined nuclear file agreement. Thank you.
Okay, what do I think about the ILC project on the formation of international customary law? I think it is quite disappointing. I mean, the rules published by the ILC in this field, I think they are very conservative. They don't reflect what's happening in the real life of formation of international customary law. I talked with two members of the commission about that, and both of them said something like, yes, we are very conservative about that, and it should be like that. I think, for example, what about the role of non-state actors in the formation of customary international law? So according to the ILC rules, we are talking about only secondary rule, marginal rule. I mean, we are talking about the contribution of international courts or international organizations. Nothing, almost nothing, yeah? And I think that it is quite disappointing. And similarly, last year I talked about the ILC rules on use cargoes, also quite conservative rules. So when I think about these ILC rules on immunities, at least we have one article, Article 7, that it is a controversial, but the ILC here adopted here a more active stance, and I think that it is quite good. But the price, of course, is that since you have some controversy about Article 7 with regard to international crimes and immunities, the price is that some tribunals like the ICJ would say, since there is a controversy, it doesn't reflect international customary law. So there is some price to be paid. But again, if you ask me about the ILC work on the formation of customary law or identification of customary law, I think it's very conservative. It doesn't reflect lawmaking in the real life in the international community.
Well, sorry for not being clear. I think the change in policy comes from the side that is losing the war, okay, losing the cyber wars. So you see, so after 2016 was a bad year because you had the elections basically manipulated. Countries that have elections are more susceptible to these sort of changes than countries that do not have elections. Then you had in 2017 these global attacks. I mean, this WannaCry and NotPetya. And now basically you have the whole supply chains of the whole industry compromised. So if you see that the existing strategy, which is built on deterrence, okay, covert and covert retaliation is not working, and you're in a way you're bleeding resources, trust, reputation, what have you, then you think of other paradigms, and multilateralism seems like one way to go. I'm not sure that it will succeed, but it seems like that the previous paradigm that was dominant for the last 10 years and for the first 10 years of this reality simply is not working for the Western countries that are trying now to move multilaterally.
Thanks. We have time for one more question, maybe. But if we don't have any more questions, then we'll take a break and we'll reconvene at 6 for our last panel.